This year, 2026, Israel introduced two new capital crimes in the death penalty for terrorists law. The first exists in the Israeli national legal system, operating in what Israel claims is its sovereign territory, meaning Palestine within the 1949 Green Line plus East Jerusalem and the Syrian Golan Heights. This national legal system can also cover acts performed outside this territory, notably in the Palestinian Gaza Strip and occupied parts of Lebanon and Syria, in addition to the Golan Heights. The second crime exists in the military legal system Israel operates in the Palestinian West Bank, not including East Jerusalem. Both crimes cover intentional killing in circumstances meeting the definition of terrorism in Israeli law. The crime in national law also requires the aim of negating the existence of the State of Israel. By implementing these crimes, Israel commits serious breaches of two fundamental international law obligations. First, the Palestinian legal right to self-determination and the related legal right to resist. Intentional killing can be lawful as an act of resistance if conditions are met, for example, if the target is not a civilian. The Israeli definition of terrorism is broad enough to encompass lawful acts of resistance. Likewise, the special national law requirement of the aim of negating the existence of the State of Israel is broad enough to cover lawfully realizing, partially, Palestinian self-determination. Such partial realization would mean the existence of the territorial dominion of Israel would be significantly reduced from the current situation of all of Palestine to only recognized Israeli sovereign territory, meaning only Israeli-controlled Palestinian territory within the 1949 Green Line minus West Jerusalem. Also, such partial realization of Palestinian self-determination would result in the existence of the State of Israel as a specifically Jewish state, a state of and for Jewish people exclusively, rather than a state where Jewish people live as equals with others on the same land without supremacy. This Israel, Zionist supremacist Israel, would indeed be entirely negated. Ending racial discrimination generally, and apartheid in particular, would negate the current state of Israel as a racist apartheid state. Enabling Palestinian refugees to return would negate the current composition of Israel's citizenry as skewed artificially in favor of Jewish Israelis. Both offences therefore criminalise Palestinian resistance to Israel's own international illegality, resistance which is lawful pursuant to the Palestinian right of self-determination. In adopting them, Israel commits serious breaches of that fundamental right. The second fundamental illegality is of the prohibition of racial discrimination. In different ways, but with the same result, the new crimes apply only to Palestinians and not Jewish Israelis. The national law crime, on its face, applies to everyone. However, the requirement of an aim of negating the existence of the State of Israel is, in all likelihood, only ever going to apply to Palestinians. For the military law crime operating in the Palestinian West Bank outside of East Jerusalem, Israeli citizens and residents, covering therefore all Jewish citizens, soldiers and settlers, are expressly excluded. Most Palestinians there don't have Israeli citizenship or residency, and so are covered. Overall, this means Israel now has a new criminal regime with the death penalty, effectively applying to only Palestinians and not Jewish Israelis. This is not an accident. It was the intention of the law. The so-called death penalty for terrorists law, then, actually excludes Jewish Israelis committing intentional killing, meeting the Israeli definition of terrorism. Jewish settlers doing this in the West Bank, for example. If one word is to be attached to this law, then, that word cannot be terrorists. In truth, it should be called the death penalty for Palestinians law. Applying the death penalty to one racial group and excluding another racial group from such application on the basis of the racial difference between the two groups is a paradigmatic case of unlawful racial discrimination and, as such, constitutes a serious breach of Israel's fundamental obligations in international law. The Palestinian right of self-determination and related right to resist, and the prohibition of racial discrimination are not the only international law violations. The new crimes violate the human rights law fair trial standards and prohibition of torture and other cruel, inhuman or degrading treatment and punishment. Also, their racially discriminatory nature is part of the broader illegal system of apartheid and genocide. Israel's illegal presence in a significant area of territory where the crimes apply renders this application illegal, being part of an exercise of authority that is itself illegal. The nature and international illegality of these new arrangements can only be fully appreciated when they are placed in a wider context. The Israeli raison d'être is that Israel, as a Zionist state, a state for Jewish people exclusively, exists in and is the exclusive sovereign over Palestine. The Palestinian people are a fundamental impediment to this, and the Zionist attempted solution to what is, for it, the Palestinian problem, involves three policies and associated practices. First, removing Palestinians from Palestine. This is furthered through killing, as has reached a genocidal apogee in the Gaza Strip, and forced displacement, something which, in particular, spiked on and from 1947-1948, the Nakba, 1967, the Naksa, and 2023, the Gaza genocide, entrenched through denying refugee return. Second, the subjugation, immiseration, incarceration, and systematic abuse of remaining Palestinians. Third, the elimination of Palestinian objection and lawful resistance to all of this. The Zionist enterprise necessarily operates through a racialized distinction, privileging Jewish people over non-Jewish Palestinian people. For the Palestinian people, it is this racialized distinction, that they are not Jewish, that is the basis for their removal from Palestine through killing, displacement, and non-return, and the subjugation, immiseration, incarceration, and systematic abuse of those who remain. Conversely, for the Jewish people, it is this racialized distinction that they are Jewish that is the basis for their ability to live in a state conceived to be of and for them exclusively, with all Jewish people everywhere in the world enjoying a right to this life through emigration and citizenship. The dialectic between Jewish supremacy and non-Jewish Palestinian subjugation is of its essence racist, requiring Israel to operate as a state and exercise dominion over the territory and people of Palestine through racial discrimination generally and apartheid in particular. Moreover, of necessity, it's Jewish Israelis with crucial external support who have to perpetrate the killing, displacement, prevention of return, subjugation, immiseration, incarceration, and systematic abuse of the Palestinian people. And the continual conduct of these practices has to be an integral part of their life and the operation of the Israeli state. The death penalty law is but the latest manifestation of this broader Zionist enterprise and the catastrophic effect of that enterprise on the Palestinian people. As such, it builds on existing features of the enterprise. This law permits Jewish Israelis to intentionally kill Palestinians through acts that would meet the Israeli legal definition of terrorism without the risk of facing the death penalty under it, despite this penalty now existing in this law for intentional killing meeting this definition. This is rooted in and further extends the general concept of Jewish racial privilege. Jewish Israelis, because they are Jewish, being given a lesser penalty for the same crime when compared to that which Palestinian people, because they are not Jewish, will get. This risks incentivizing and so enabling race-based killings of Palestinians by Jewish Israelis, supplementing the opportunity they already have to do this through military service. Furthermore, it will potentially mean the Israeli state killing more Palestinians. Here then, the existing means of Israeli state conducting killing of Palestinians, military action, is supplemented through judicially sanctioned executions, enabling more killing of Palestinians by both individual Israelis outside of military service and the Israeli state is, again, rooted in and a further extension of the first policy of the Zionist enterprise, removing Palestinians from Palestine. Generally, and in particular, is a new way of furthering the third policy of the Zionist enterprise, eliminating Palestinian resistance, adding new means to the most extreme practice for implementing that first policy of Palestinian removal, the killing of Palestinians. Just as the law builds on the existing features of the Zionist enterprise, so too the way it seriously violates fundamental rules of international law builds on the other serious violations of such rules integral to that enterprise. As I've explained elsewhere, including before the International Court of Justice, the rules seriously violated are the Palestinian right of self-determination, the core norms of international humanitarian law, and the prohibitions of aggression, genocide, crimes against humanity, racial discrimination generally, apartheid in particular, and torture and other cruel, inhuman, or degrading treatment and punishment. Necessarily, then, the nature of the death penalty for Palestinians law and how it seriously violates fundamental rules of international law have to be understood and addressed, not in isolation, but as part of something relatively more long-standing, profound, wide-ranging, and fundamentally serious.